Do we have a quorum, Madam Secretary?
Yes, we should.
Okay. I need some kind of acknowledgement. I know I see Ms. Gray, Mr. Pryor. Okay, I think we do have a
Mr.
quorum.
Robbins, yeah.
We do have a quorum.
All right, great. Today being January 5th, 2022 is now 12:01. I call into order the meeting of the Operations and Oversight Committee. Before we proceed, Madam Secretary, will you take attendance and announce whatever announcements need to be made?
Yes,
meeting?
thank you. This meeting is being conducted virtually, so I will do a roll call of the trustees to confirm attendance. Mr. Knox? Ms. Gray? Mr. Bernstein?
Here.
Mr. Sanchez?
Here.
Mr. Moore?
I'm here.
Mr. Robbins?
I'm present.
Mr. Pryor?
Here.
Mr. Harris?
Here.
Ms. Zapanta and Mr. Kehoe are not attending. Staff participating in the meeting include CEO Santos Kryman, Deputy CEO Louis Lugo, AEOs JJ Popowich and Laura Guglielmo, Chief Counsel Stephen Rice, James Beasley from Admin Services, and Fiduciary Counsel Robert Klausner. Trustees, please use the Zoom chat option to be placed in queue. At this time, we ask all meeting participants to mute your mics until you are ready to speak, and we may now proceed with the agenda.
Great, thank you very much for that. Since Mr. Kehoe is absent, Ms. Gray will be a voting member. At this point, I will entertain a motion for the approval of the minutes of the regular meeting of December 1st, 2021.
So moved.
Second.
It's been moved and second. Any changes, questions, deletions? Hearing none. Roll call, please.
Mr. Robbins,
Aye.
Ms. Gray,
Aye.
Vice Chair Santos.
Aye.
The motion passes unanimously.
Great, thank you. Next item on the agenda is public comment. Have we received any requests to speak?
Yes, Brian Ross, the attorney for Todd Hipsher, made a public comment at the Board of Retirement meeting regarding the OOC item 3B. That's
Great,
it.
Thank you for that. And Mr. Rice, at the appropriate time, I will be requesting for you to respond to some of the comments made by the attorney at the beginning of the Board of Retirement meeting.
Yes, I would like to do that. Thanks.
Thank you, sir. Moving forward to item 3, subsection 8, recommendation by James Beasley regarding the authorizing an RFP for insurance broker services.
All right. Can you guys hear me? I had to actually go on my phone rather than Zoom because I was having technical issues. So I want to make sure you guys can hear me.
We hear you loud
Yes,
and clear.
we can.
All right, perfect. All right, good afternoon, Ms. Chair and members of the committee. I am James Beasley with Administrative Services, and today I am coming to the committee to request approval to release a formal RFP to solicit bids for insurance brokerage services as presented in the memo. Why is having an insurance brokerage firm necessary for LACERA? The best answer is that an insurance broker acts as our subject matter expert who can assist us with the complexities of the various types of coverages, fluctuating rates that vary by industry, and determining which type of insurance best suits LACERA's operational needs. Insurance brokers are experienced professionals who are equipped to assist LACERA in making decisions that are in our best interest. The broker acts as an intermediary between LACERA and insurance carriers. The broker is familiar with LACERA's business and uses the insurance expertise to locate the best comprehensive insurance programs that meet our needs and at a reasonable cost. LACERA has been with our current insurance broker, Carter Campbell, for many years, and they have provided LACERA with excellent service. Their services consist of researching each insurance plan, measuring each policy plan against organizational risk, conducting competitive bidding for insurance quotes, and providing recommendation on insurance packages for LACERA's consideration. LACERA's purchasing policy requires us to conduct competitive bids on long-term service contracts every 5 years. This allows us to survey the marketplace so that we can provide transparency, equality of opportunity, and identify the best value for LACERA. For this RFP, we are seeking a brokerage firm to act as an independent insurance advisor to LACERA and proactively provide ongoing, unbiased professional advice and recommendations that are practical and pertinent to LACERA. This includes, but not limited to, proactively providing ongoing review and analysis of LACERA's insurance programs and identifying risks and recommendations to mitigate those risks. Continually monitoring LACERA's operation and loss exposures and providing appropriate recommendation for coverage changes or adding new coverages. And then finally, providing insurance claims processing and consulting services as needed. We plan to release the RFP to the public immediately after the committee approves the request. In addition to being posted on LACERA.com, we plan to invite approximately 40 different firms within the Los Angeles County area to participate in the bid process. We will post the RFP online for 30 days, and then we will proceed with the bid scoring and selection process, which will be conducted by the review team. This team is staffed from executive office, legal office, systems, and administrative services. We anticipate having a contract drafted and signed during the first week of March to allow adequate time for selected firms to begin obtaining quotes for the June 30th renewal. More importantly, this RFP process will not affect the current insurance policies that are in place with the various insurance carriers. The policies will continue to remain in effect until their expiration date. This concludes my presentation. Please let me know if you have any questions. If not, thank you for your time and have a wonderful day.
Thank you for that presentation. Any questions, comments, concerns, motions?
I have a question. Just what's the value of this contract range?
It's brokers right now with our current contract with our broker. It's done by a commission, so it's commission based on the premium that is for each policy, and we average for this last year we averaged about 10% for all 12 of our policies.
So what's the dollar value?
It was estimated for 2021 fiscal year around 100,000.
Okay.
Any other questions about a motion? We need insurance.
Well, there's got to be a committee.
Ms. Gray.
I'm
I'll move it.
Okay.
couldn't find my unmute button.
So we have a motion. Mr. Raven, second by Ms. Gray. Any discussion on the motion? Seeing none, roll call, please.
Mr. Robbins,
I'm an aye.
Ms. Gray,
Yes,
Vice Chair Santos.
Aye.
The motion passes unanimously.
Great. Thank you very much for that.
Thank you.
Moving forward to 3, subsection 8, recommendation by Mr. Rice for the committee to approve the revised admin appeals procedure for felony forfeitures.
Thank you, Trustee Santos. The Court of Appeal in the Hipshire litigation that many of you are very familiar with, LACERA has been in for a number of years, decided about a year ago that the felony forfeiture statute in PEPRA was constitutional, and that LACERA, not the County of Los Angeles, had the responsibility to provide due process before a forfeiture could be imposed. This has caused us to review our current policy, which provides a process whereby the member can speak in public comment, and then the board decides the issue in closed session where the member and the member's counsel, if the member has counsel, are not present. The Hipshire court did not dictate a specific form of due process. The only guidance that the court gave was that the member is entitled to notice and is entitled to an opportunity to express their objections to an impartial decision maker, which would be the board. That's all the guidance that was provided. We could have asserted that our current policy satisfied that standard, but in thinking about it, we really didn't feel that given the magnitude of many of these forfeitures, the importance of this issue, the fact that we are talking about a vested right, we thought that we should do more and do better. So the current policy completely changes the rights of the members to address the board. So instead of simply having the opportunity to address the board in public comment, we bring it onto the agenda and have basically potentially up to a two-phased process, but we give the board options. The Court of Appeal in Hipshire recognized that the facts and issues in felony forfeiture cases are going to vary greatly. There are going to be many cases, and the court really thought that this would be a majority of cases where the job relatedness of the felony was clear, and that the proceedings in the criminal court would really be sufficient to provide due process, and that very minimal additional procedures would be required at LACERA. However, there are going to be other cases where there are shades of gray, there are more nuances, there may be plea agreements as opposed to convictions after trial, and other issues that may make the cases more complex. So in recognition of that part of the Court of Appeal opinion, what we've done in this policy is provide an opportunity for members to come in with their counsel and address the board based on written determinations by LACERA and written objections by the member, but speak to the board for 5 minutes, with 5 minutes by LACERA and then 2.5 minutes for rebuttal by the member, exactly as is done in disability retirement cases. And then after hearing that argument, the board has the option to just decide the issue at that point in time and affirm the forfeiture that staff is recommending. The board could modify the forfeiture, or the board could send it out to a referee. And that process would be based on the procedures that we already have in place on the disability retirement side and the policies and procedures that are well established there. And this provides the member with due process, and it provides the board with flexibility as to what type of information it needs to make a decision and what it thinks on a case-by-case basis is fair for the member. So this goes actually above and beyond what was literally required by the Court of Appeal case, which was only notice and an opportunity to come in and speak to the board. An evidentiary hearing is not required by the Hipshire opinion. It did not state that I want to emphasize this, it did not state that that was required, and that's why we don't provide for it in all cases. So now, if I might, Trustee Santos and committee members and trustees, I'd like to address Mr. Ross's comments because they're worth discussing briefly. Before I do that, the process that we followed here was a little bit unusual because we sent copies of this policy out to member council and actually invited them to either attend the meeting or participate in public comment and make their views known. Mr. Ross was the only one who took advantage of that offer, but we solicited comments because we wanted to make sure that the board had the member perspective on what we were doing here. So Mr. Ross made a number of comments, and I'll just go through them briefly one by one. First of all, he said the hearing time was too short. recommend to the committee for its consideration and action that we maintain the same time periods that are provided in the policy now, the draft policy you have, which are the same time periods that are provided to disability retiree applicants. The next comment he made was that the hearing doesn't allow for oral testimony. That's correct in the first instance, but the member is free to request oral testimony from the board, and if the board thinks that's appropriate, then the board would send that out to a referee. It would be inconsistent with the recognition that the Court of Appeal made that some of these cases are very simple and some of them are more complex for our policy to blanketly provide that there would be referee hearings in every case. And so we would suggest that we maintain the wording of the recommended policy with respect to that issue. The next issue he raised was respect to the type of writ that would be filed in Superior Court, and Mr. Ross suggested that we specifically call out that the writ would be what's called a CCP 1085 writ. The prior policy specified 1085. The board, no matter whether we specify a statutory provision as to the type of writ, or whether we just simply say, as the proposed policy does, that they have the right to file a writ as provided in the Code of Civil Procedure. It really doesn't matter when you get right down to it, because that's a decision for the court, and the member would have the opportunity to argue to the Superior Court what type of writ. The difference between the writs is that a 1085 writ is to compel a public body to perform a legally required duty, whereas the other type of writ, which is a 1094.5 writ, comes into play where there is a requirement by law that a hearing be offered, and here there is not a requirement by law that a hearing be offered. There are some nuances here because of the range of these cases and the complexity. I actually would have no objection to specifying the 1085 writ, going back to the way we had it previously, provided that we just understand that ultimately this is going to be an issue for the court to decide. The court will decide what its standard of review is. The next issue was stating in the policy the burden of proof. So first of all, what is the burden of proof? Well, the burden of proof lies with LACERA to establish that there is a job-related felony and what the date of first commission of that felony was. That's LACERA's burden. And if LACERA doesn't meet that burden, then the board should not impose a forfeiture. This burden, the burden I just stated, is already in the policy in the section that relates to the initial staff determination. I think it's probably reasonable for Mr. Ross's point that it should also be in the section that deals with the board's consideration. So I would have no concern, and in fact agree that we can repeat that burden statement in the section of the policy that deals with the board's portion of this process. The next issue related to narrowing subpoena power so that it only related to well, it was unclear how he wanted to narrow it. Basically, what he was arguing is that the board is limited to the paper in the criminal file that constitutes the conviction. That is not in PEPRA, and it's also contrary to Searle, because Searle gives the board broad subpoena power. If a subpoena was requested and the member thought by the member or LACERA, and either party thought that it was overbroad or improper, the board could hear those objections, and that would be part of the process. But we recommend against taking Mr. Ross's suggestion to narrow the board's statutory subpoena power. We believe that would be inappropriate. Next, Mr. Ross made a series of evidentiary issues, and it would not be appropriate to bring to try to anticipate what all the evidentiary issues would be in these hearings. They're going to vary from case to case, and exclude or admit evidence in advance. That's for the board to determine or for a referee to determine. And there's nothing in the policy that waives that right. It's in the disability procedures for a referee proceeding. So there's no need to make any changes to the policy to address that. The member's right to make evidentiary objections is not waived or limited by this policy. And then finally, Mr. Ross requested it be that the method of members filing of their appeal and other documents in order to be timely on the under the policy be specified, and that's a fair comment. So we will, if the board, if the committee approves the policy or recommends it to the board, and the board ultimately adopts it, we would want to add language that provides for electronic filing by email if the member wishes, or by mail, that it would be effective upon mailing. So those are my comments to Mr. Ross's comments. I'm glad he made them, and they were well considered. We know his firm well and have respect for them, but there are only a handful of his comments that I think should actually be included in the policy. So with those revisions that I've mentioned, I would be happy to take any comments, but would request that the committee consider recommending the policy as with those couple of revisions to the Board of Retirement for adoption.
Thank you, Mr. Rice. Any comments, questions, concerns, motion? I will move approval of the staff recommendation, including the amendments that Mr. Rice just put forward.
I just have one, well, I second that motion, but I do have one question of Mr. Rice. The Hipshire case has already been decided, or do we now have to have, based on our new proposal of procedure, are we going to have another hearing for Mr. Hipshire? So
we have 3 felony forfeiture appeals in the queue right now, and Hipshire is one of them, because what happened in the case was LACERA staff had imposed a forfeiture. He filed a writ of mandate, a 1085 writ of mandate, challenging that, and also the constitutionality of the statute. What happened in the case ultimately in the final judgment is that the statute is constitutional, and that LACERA's staff action is sent back to LACERA to offer due process. And that's what so his case will be coming back to the board in one form or another in the next several months.
But it doesn't really offer him a different outcome, just the proper procedure.
It doesn't guarantee him a different outcome, no. But the board should have an open mind, and you'll be hearing this as independent decision makers when it's presented back to him. And he filed his appeal last fall. As I mentioned, we have 2 others as well, for a total of 3, and all of those cases will be coming to the board for the first go round, probably starting in March, April, May time period.
All right, thank you, Mr. Rice. As you know, this is one of my favorite cases.
Right, I know you. It's one of yours.
All right.
Any other comments? Questions? Now, we do have a motion that was duly second. Roll call, please. And this is a recommendation from this committee to the Board of Retirement to adopt the staff recommendation with Mr. Rice's amendments. Roll call, please.
Mr. Robbins? Mr. Robbins? I'll come back. Ms. Gray?
Yes.
Vice Chair Santos?
Yes.
Mr. Robbins?
We should get his acknowledgement because without his presence,
We don't have a
we've
quorum.
lost.
Mr. Robbins, are you there?
Maybe text him.
Could we hold, Mr. Rice, can we hold this vote on abeyance, move forward to reports and hope that Mr. Robbins may come back?
Yes.
Okay, we're going to hold this matter until we have a full quorum. At this point, we're moving to section 4A reports. LACERA operation briefing. Mr. Lugo.
Yes, good afternoon, Vice Chair Santos, committee members. Really, we'll stand for questions for our operational and administrative updates, but I do want a general acknowledgement to Cynthia Martinez within our communications team, as well as Ted Granger. They recently published our annual comprehensive financial report, as well as our popular annual financial report to our website about a week or two ago. So that's active for our members and public to view. And just wanted to again reiterate and recognize the work and effort from those two teams. It is a collective effort around LACERA and working through our annual financial report, but definitely the heavy lifting as it relates to the branding and look, it goes to our communication team. So I just wanted to acknowledge the team for that. With that, we'll stand for any questions as it relates to our operations report.
Yeah, if you can discuss briefly the COLA bank retroactive changes. I'm not quite clear on that.
Yes, I'm JJ. If I can have you speak to the COLA bank project, please.
Absolutely. So you may recall that we discovered a discrepancy in the COLA bank accrual methodology, and we made a time forward correction for all members. I believe it was in July of this year, or excuse me, April of this year. No, July of this year. I apologize. And there was a number of members that needed to have retroactive adjustments made. So we did a group of those members via an automated process working with systems. And then there was a group of members which required manual processing because of the complexity of their their accounts. And so we still have about 1,000, a little over 1,000, a little over 1,500 members, which we're still working on. 508 of those are currently being worked on by our benefits group. We had promised to them that we were going to get all of these corrections done by December 31st. Unfortunately, we didn't make that date. So we are sending out notices that we are continuing to work on getting these corrections done. I've met with the team. We're trying some different approaches to applying our resources and getting resources to be able to get this done as quickly as possible.
Great. Thank you for that. Is there any other questions on the report? Seeing none, going back to the previous item, which was action item 3B, Bravo, regarding the felony forfeiture. Mr. Robbins, we have a motion on the floor to recommend to the Board of Retirement that we approve the staff recommendation, and Mr. Rice made some amendments to that. I will ask for a roll call again.
Mr. Robbins,
I'm an aye.
Ms. Gray,
Yes.
Vice Chair Santos.
Yes.
The motion passes unanimously.
Thank you. I also want to mention that we add the benefit of Bob Klausner's involvement as fiduciary counsel in putting this policy together, and it does reflect his edits. He has many years of national experience in felony forfeiture matters. So thanks to Mr. Klausner.
Thank you indeed. Appreciate it. We knew about you when we hired you.
Always a pleasure.
Wealth of experience.
Thank you.
Okay, so that concludes, items for a staff review. I don't believe there's none.
No, there is none.
Okay, good of the order. Anybody would like to say a few words? Seeing or hearing none. I will entertain a motion to adjourn.
So moved.
Thank you. Have a wonderful afternoon.
Happy
everyone.
New Year, everyone. Stay healthy and safe.